Good morning, everyone. And notably, and I speak on behalf of other colleagues that will give the presentation today. We are pleased to see so many of you registered and participating. We have received some questions from you in advance, and we'll aim to cover these in our presentations. We would like to inform you beforehand that this webinar is not dedicated to country specifics, such as particular authorization process in any of the Baltic countries or matters that are not in the scope of MiCAR. However, we are considering to arrange more webinars relating to the topic in the future. So if you have any topics that would be in your interest, please share these with us. As for today's webinar, you are welcome to send your topic-related questions to us also during the webinar through the Q&A window, and we will try to discuss answers to these in the end of the webinar or send answers in writing during the webinar if we have time. You are more than welcome to send questions and inquiries to us also individually by email, especially if answering requires a longer analysis or more information about the background of the issue. Our presenters' email addresses can be found on the slides and on our website. We will share the slides and recording of the webinar with you after the event by email and also post them on our website events section. So, as all of you know, today is dedicated to the famous MiCAR, which stands for Markets in Crypto Assets Regulation. We will try to navigate this new regulation with Sarainan professionals from Estonia, Latvia, and Lithuania. So without further ado, I give the floor to my dear colleague, Agneta Rumpa, Senior Associate with Sarainan, Latvia. She will be covering the topic General Framework, Key Concepts of MiCAR, and Timeline of its implementation. And we'll begin this wonderful journey of crypto world today. Agneta, the floor is yours.
Hello. I join the delight that my colleague Aquila expressed that we get to give a presentation about crypto to such a broad audience and also to such a serious audience involving lawyers, businesses, financial regulators, and others, especially considering that crypto not such a long time ago was considered, and I quote, called scam, just useful for money laundering or fraudulent purposes, or about to completely not exist. So today's presentation and our topic is a complete proof of the contrary, because we are about to discuss, I would say, one of the most significant governmental endorsements to the topic of crypto. So we are about to discuss markets in crypto assets regulation, a European Union regulation, which is in fact the first regional and crypto-specific regulation in the whole world. So now it's a completely change of scenery in the European Union, because now we will have uniform rules for the crypto market, which is a really different situation from that was so far, where there were some rules in some EU member states, no rules in most of the others. What will be the actual impact of this regulation? The time will tell, because of course, even though this is a significant step for the crypto world, nevertheless, European Union is just a small part of the global crypto market. As with any regulation, I believe that we always have to start with the question why. So why was this regulation necessary? Well, if we look at the not so long history of crypto, it has been very, very eventful. And recognizing this, also this regulation was passed. I have listed a couple of reasons for passing MiCAR, which can be found in the regulation itself in its recitals. I will just focus on two of those, which I believe to be the most significant ones. So the first reason, of course, was to protect the clients of different types of crypto services. Probably each of you has heard at least a couple of scandals or downfalls of large crypto companies. Maybe one of the largest ones was actually at the beginning of this year when FTX, one of the largest crypto exchanges in the world, collapsed, and now it's in bankruptcy proceedings and it owes its clients up to 8 billion US dollars worth of crypto assets and also other types of assets. Another reason for this regulation was to introduce some rules that would actually support market integrity and financial stability. So this actually goes back a couple of more years. You probably remember that Facebook, one of the largest companies in the world, was planning to introduce its own cryptocurrency. The governments worldwide were very, very concerned about this idea because the plan was to link this cryptocurrency to actual fiat or real world currencies. This could, of course, have a significant effect on the real economy just in case something went wrong with the particular crypto. So now in 2023, we do not have such a crypto that was supposed to be developed by Facebook. There's also different other reasons why this regulation was necessary, but yes, these two I believe to be the most significant ones. So what is the main topic, the subject matter of the MiCAR regulation? This again can be found in the very beginning of the regulation in one of the first articles, and the idea is to introduce uniform requirements for crypto assets, namely for the issuance and offering of crypto assets to the public or trading them on some type of platform, and also for those persons that provide services relating to crypto assets. So as you will see, and as my colleagues will explain into more detail later on, MiCAR only concerns crypto services which are happening via intermediaries. So it does not really cover peer-to-peer transactions relating to crypto. So more particularly, MiCAR covers different types of requirements for crypto asset issuance and offering. So this actually is one of the many ways how this new regulation will resemble the existing regulation of financial instruments, which, as you probably are aware, have specific and very strict requirements for their offering and issuance. Also, there is no more the Wild West for crypto assets, at least not in the European Union, because all crypto asset service providers actually will be subject to authorization, supervision, operational, and all kinds of other requirements. Again, one new aspect of this regulation is that now crypto asset holders and other crypto asset services clients will be protected. So far there was some regulation relating to this in specific member states of the European Union. In other member states, such as for instance Latvia, there was no specific protection relating to these services, just the general consumer protection. But now it's going to be much more specific and concrete. And similarly, again, as for financial instruments, there will be market abuse prevention measures relating to crypto asset sales. Any regulation to understand how it works, unfortunately, we do have to start with the perhaps not so exciting things, and these things are definitions or key concepts. So this regulation, in crypto assets regulation, introduces concepts such as crypto assets, and there are different types of crypto assets concerned by this regulation. It also mentions distributed ledger technology, which also is a term that probably most of you have heard in relation to crypto. And it specifies what type of crypto asset services and their providers are covered by the regulation. So starting with the very, very basics. What are crypto assets? Before this regulation, there were different types of terms actually used in relation to crypto. They were named digital currencies or virtual currencies, but now we do have this term of crypto asset, which is a digital representation of value or rights, which can be stored or transferred electronically. And this all happens by use of some type of technology. One possible type is distributed ledger technology that I mentioned before. So if we look at this definition, definitely it is quite broad, and it's evident that it doesn't only cover crypto assets such as cryptocurrencies or payment tokens. And also these types of crypto assets are also divided into separate sections that we will discuss a little bit in more detail in the next presentations. One type is e-money token, another type is asset reference token. So both of these are particular types of crypto assets because they are referring to specific types of assets. So e-money token is a token that is only referring to one specific type of official currency, whereas asset reference token can refer to several currencies or several classes of assets. And by these links to these assets, these types of cryptocurrencies are supposed to, or are at least trying to maintain some sort of stable value. So before MiCAR was passed, there was and still is the term of stable coins. So if you're thinking stable coins, they will likely be covered by both of these definitions, by either of these definitions. There, of course, are all kinds of other crypto assets that are not falling into one of these categories. And MiCAR does not really discuss each possible type of other crypto asset. It only also mentions utility tokens. So these would be types of crypto assets that are issued by some service provider or by some business, and that enables users of these tokens to purchase services or products and have no other type of function. So if we're thinking about real life examples, what could fall into these different types of classes? Definitely the most popular types of cryptocurrencies would likely be covered by some of these definitions. Like I already mentioned, stable coins such as Tether or USD coin, those would likely fall into the scope of e-money tokens. When we're talking about more known crypto assets such as Ether, which is the native token of Ethereum blockchain, or Bitcoin, which is the original cryptocurrency, or some even call it the gold of crypto assets, the response in which type of crypto asset class they fall is not going to be that easy to determine, because based on what they are used for, they can either fall under scope of other types of crypto assets, or Ether can also be considered as a utility token because the main function of it is to access and pay for transactions occurring in relation to Ethereum blockchain. An important thing to consider is that that blockchain, or the technology which is relating to these cryptocurrencies, is not covered, and it is not meant to fall under the scope of crypto assets of the regulation. Speaking of technology, one important aspect of MiCAR is that it is supposed to be technology neutral. So what does it mean? Of course, the European Union wants this regulation to last for at least some time. So the regulation is not restricted to the cryptocurrencies as we know right now. just the ones that are, let's say, recorded on specific types of blockchains or specific types of distributed ledgers. It's supposed to work on for any type of technologies. However, to acknowledge that most of the cryptocurrencies are in fact relating to distributed ledger technology, the MiCAR also mentions what it is. Most of you probably do know that the distributed ledger technology, it is a technology that enables recording information in a distributed in a distributed manner. So meaning basically it is a non-centralized or decentralized ledger, and the technology is which allows these transactions to be recorded and also to happen. And the final point that I wanted to mention in relation to key concepts is crypto asset services and crypto asset service providers, because most of the MiCAR regulation actually concerns these services. And this is another aspect in which MiCAR does resemble the existing European Union regulation. So basically, if we look at this list of crypto asset services, like custody and administration of crypto assets, or operation of trading platform or exchange services, basically all of these are already mentioned in another regulation in actually the markets, the MiFID directive that relates to financial instruments. So the European Union legislators decided that they do not want to invent anything new. They just applied the same types of concepts of financial instruments also to crypto services. And the crypto asset service providers are any types of entities that provide one or any of these services here. Again, what does it mean in real life? Most of the platforms that we associate with crypto services, like exchange platforms or some of the wallet providers, like you probably have heard names like Binance and Coinbase, and I also already mentioned the now infamous FTX. All of these service providers would actually fall under the scope of MiCA regulation if they wanted to provide their services in the European Union. So this means that once all of the MiCA regulation provisions come in operation, they will need to establish here. But this will be covered by my colleagues further on. So I'm almost out of time with my presentation, so it's perfect that we actually do have to discuss the timeline of MiCA a little bit. I will only mention the most important things. So one thing is that MiCA was passed and it has entered into force this summer. However, not all of the provisions are already operational. The provisions that relate to e-money tokens and asset reference tokens, these will apply starting from mid next year, from June 2024, and other provisions will start to apply starting from the end of next year, so December 2024. There's also different types of regulations that are relating to crypto and that still need to be passed. Also, all of the member states still need to introduce their legal frameworks that work with MiCA. And again, all of this will take time. So even though I'm really glad that we do have this regulation now, I am a bit concerned that unfortunately this legislative process of European Union does not seem to keep up with the rapid pace of technology. Thank you very much for your attention. I will now pass the mic on to my colleagues.
Thanks, Agneta. Thanks. Very interesting presentation. Now let's move on to the next speaker, Krista Shevrev, associate with Sorainen, Estonia. She will present the topic types of crypto asset issuers, requirements for offering and admitting to trading of crypto assets. Krista, the floor is yours.
Good morning, and thank you, Aquila. So yes, as mentioned, we will continue this webinar with an overview of types of issuers, requirements for offering and admission to trading of crypto assets. I will attempt to zoom into the most notable parts of this part of the regulation with the limited time that we have today, but this will certainly not be a comprehensive overview. So in case of any questions, it might be necessary to discuss those separately. So the first thing to note is that issuance itself is not regulated. The offer to the public or admission to trading is. The definition for an offer to the public is familiar to some from the prospectus regulation. And as you can see from the slide, it is very wide and it's not too connected to the word public, as many might expect. So it's a communication to persons in any form, by any means, presenting sufficient information on the terms of the offer. MiCAR is structured so that separate parts of the regulation apply to the offering of different types of tokens. So as previously mentioned, there are separate requirements for issuers of asset reference tokens, e-money tokens, and what we call general crypto assets, which are simply crypto assets within the meaning of MiCAR that do not fall under either of the previous two. So the MiCAR starts with the so-called general crypto assets offering. There are certain grounds upon which the offering requirements under MiCAR do not apply at all. As you can see from the slides, where the crypto asset is offered for free. However, it's important to analyze in each case whether the token is in fact offered for free, because MiCAR states explicitly that the offer is not made for free, for example, in case personal data is provided to the offer in exchange, or where the offerer receives any other fees, commissions, monetary or non-monetary benefits in exchange for the crypto asset. Also, where the crypto asset is automatically created as a reward. So this is the process commonly referred to as staking, where the offer concerns a utility token, providing access to a good or service that exists or is in operation. This means that the full public offering requirements apply where there is a project for issuing a utility token for any kind of future service. And then finally, where the holder of the crypto asset has the right to use it only in exchange for goods and services in a limited network of merchants. This exemption is familiar to some from the payment services regulation, and as many of us know, also needs to be assessed carefully case by case. So also these exemptions do not apply where the token is subject to offer. The token subject to offering will be admitted to trading and the intention is made known. Next, there are some additional exclusions applicable under MiCAR, but due to the fact that these exclusions do not exempt the issuer from all of the applicable requirements, we call these private offering exemptions for the purpose of this webinar at least. As you can see from the slides, the exemption applies where the offer is made to fewer than 150 natural or legal persons who must act on their own account, where over the period of a year, the total consideration for the offer is up to 1 million euros or the equivalent, or where the offer is addressed solely to qualified investors and where the crypto asset can only be held by such qualified investors. This term is familiar and is actually defined in MiFID II, as Agneta mentioned, the regulation, the directive covering financial instruments. And qualified investors include market players such as banks, investment firms, investment funds, and large undertakings. So therefore, any offering of crypto assets that do not fall under e-money tokens or asset reference tokens would be considered a public offering. So here we have provided the requirements applicable to private offering versus public offering. As you can see, quite a few also apply to private offering, but the most stringent ones are applicable to the public offering. For example, publishing marketing communications, drawing up and publishing a crypto asset white paper, and also notification to the local competent authority of the crypto asset white paper. This notification must also be accompanied by an explanation regarding the qualification, which means that the competent authority needs to be explained why the crypto asset that you offer should not be considered to be a financial instrument, funds or other instruments that are excluded from the scope of MiCAR, or also why it's not an e-money token or asset reference token. And to emphasize, the local authority is notified, and this is not an authorization process. As previously mentioned, the admission to trading is also something that is regulated with the same rules. So the public offering requirements also apply to a person to seek submitting crypto assets to trading. This means that where the tokens are not issued by way of a public offering, but they are later admitted to trading, the public offering requirements apply then. These requirements may also apply to the operator of a trading platform instead of the issuer, where the admission takes place on their initiative. And one other important thing to note is that retail purchases of crypto assets must be provided a 14 calendar days withdrawal rate under MiCAR. Now moving on to asset reference tokens. In order to offer asset reference tokens or seek their admission to trading, the issuer must be authorized under MiCAR or be a credit institution that follows MiCAR to the limited extent provided. These requirements do not apply in case of the exclusions shown on the slides, which again we can refer to as private offering, similar to general type of tokens, where the maximum sum of consideration is up to 5 million euros or equivalent, or where the offer is only addressed to qualified investors. However, in comparison with general token issuance, where this exclusion applies, so where we have a private offering, there is still a requirement to draw up a crypto asset white paper, notify the competent authority, and upon request also any marketing communication. Therefore, it can be said that the applicability of exclusions, or what can be called private offering parameters, still result in requirements similar to those applicable to the public offering of general type of tokens. It is also interesting to note that while the issuer has more stringent requirements because it needs an authorization, the issuer may provide written consent for other persons to offer or seek admission to trading. But the requirements still apply to the issuer, which means that the issuer will be responsible for the tokens, and this other person must also follow certain requirements and meet certain requirements under MiCAR. So in order to offer publicly asset reference tokens, the application for authorization of issuers who are not credit institutions must be accompanied by a white paper as well as a legal opinion on the qualification of the tokens. More information on the actual application is provided by Hetty in the next section. However, it's important to note that by reference to application, MiCAR refers to the need for an authorization from the competent authority. So where general crypto asset issuers must simply notify, the issuers of asset reference tokens must obtain authorization also to their white paper and the legal opinion. You may also notice that previously with general tokens, that was referenced to an explanation, whereas for asset reference tokens, it needs to be a legal opinion. Now, credit institutions must only submit the white paper for approval together with the legal opinion. And where the same issuer wishes to issue another asset reference token, they must obtain authorization again, but there is no need to submit repeating information. Now, MiCAR includes an additional regime for asset reference tokens which are classified as significant. The full list for the characteristics is provided in Article 43 of MiCAR, but just to name a few for illustration. For example, where the number of holders of the asset reference token is larger than 10 million, where the value of the token, its market capitalization, or the size of the reserve of assets of the issuer is higher than 5 billion euros. Also, there are some grounds which are a lot more vague or open to interpretation than the ones including numbers. For example, the significance of the activities of the issuer on an international scale, including the use of the token for payments and remittances, and also the interconnectedness of the token or its issuers with the financial system. It is worth noting that where at least 3 of the criteria stipulated are met, the European Banking Authority classifies the asset reference token as significant. The result of the classification is that the supervisory responsibilities transfer from the home competent authority to the European Banking Authority, and some additional obligations apply to the issuer. Voluntary classification is also possible, but the criteria must be fulfilled. Now, finally, for this part, it's interesting to note that in a situation where the volume or transactions related to the use of an asset reference token as a means of exchange is higher than 1 million transactions or 200 million euros, respectively, the issuer must stop issuing that token and submit the plan to the competent authority for keeping the numbers and the value of transaction below the threshold. This strongly relates to the vulnerability of the financial system in relation to token offerings. So it will be interesting to see how this will play out. Now, offering e-money tokens. The offer to the public can be made, or admission to trading can be sought only by an issuer who is either a credit institution or e-money institution and has notified and published a crypto asset white paper. So there is no separate authorization requirement. Only credit institutions and e-money institutions are authorized to do that. E-money tokens are deemed as electronic money. An e-money token that references an official currency of a member state shall be deemed to be offered to the public in the Union. Certain requirements from the e-money directive apply, including the voluntary exemptions. So MiCAR refers here to the optional exclusions, which can be compared to private offering grounds, which may or may not apply in a certain member state. Obligations in respect of investment of funds received in exchange for e-money tokens apply to the issuers, and the private offering is subject to an obligation to draw up and notify a white paper again. Again, the concept of significant e-money tokens is applicable, and the same grounds are applicable as we saw from the asset referenced tokens. The consequences are also the same. And a little summary of other similarities between the asset referenced and e-money tokens include that both must be redeemable at any time by the issuer. And crypto asset service providers that have admitted those tokens for trading, for example, are not allowed to grant interest in respect of such tokens. Again, it's very important to note that the concept of interest can be interpreted widely, and it could be any remuneration or any other benefit related to the length of time during which a holder of the asset reference token or e-money token holds such tokens. This could be compensation or discounts directly from the issuer or from third parties. So care must be taken there. Now, a little comparison of requirements to the content of the white paper between all 3 types of public issuance. As you may see, general type has the most requirements, probably because it includes the widest potential range of use cases for the tokens issued. But some interesting areas to note include, for example, that the information on the underlying technology is important to cover, which when other characteristics may be something that are familiar again from the prospectus regulation, these would be more specific to crypto assets. And then finally, you can see that information on the impacts on the climate and other environment-related adverse impacts must also be covered in the white paper. Also, it must contain a summary, which is brief and non-technical, and cannot contain any assertions as regards to the future value of the crypto assets. Also, there must be a clear and unambiguous statement, which is related to the risks in relation to the offering. And finally, a few words on the liability of issuers. So information in the white paper, which is not complete, fair or clear, or that's misleading, gives rise to liability by the offerer and the members of its administrative, management or supervisory body for any loss incurred due to that infringement. Any contractual exclusion or limitation of civil liability is void. Burden of proof lies with the holder of the token. And this is it from my side. I will now give the floor to my colleague, Heti.
Thanks, Krista. Let me introduce Heti. Heti Lomp is counsel with Sorainen Estonia, and she will continue presenting another very interesting topic. It's the authorization and regulatory requirements for crypto asset service providers. Heti, the floor is yours.
Good morning, everybody, and great to be here for you. So hopefully I can clarify a bit about the authorizations under MiCAR, which is my topic. The topic could be, of course, tackled much more in depth, but we're restrained by time, so let's go right into it. So first, makes sense to clarify about which authorizations we are speaking of, because MiCAR refers to other authorizations as well that are familiar from the financial sector already before the MiCAR. So MiCAR refers basically to Electronic Money Directive, to Credit Institution Directive, and also to MiFID, which covers investment services. So we're not talking about those authorizations because they are already covered by the other regulations I just mentioned. But nevertheless, they are relevant, and in that sense, I will mark them in specific sections where they are relevant. So what we're speaking about is two types of authorizations. So first is a crypto asset service provider authorization, and the second one is an asset reference token issuer authorization. So what are the key questions? How do you start? How do you pick which kind of authorization is the right one? So how we usually start is we look at the key questions, and we take a look, what is the business model? What is the intention? So from the key questions, first one is definitely, if we go for a crypto asset services, are they provided on a professional basis by a person? It could be a legal person or other undertakings in certain circumstances and terms and conditions, or are the service provided fully decentralized? So MiCAR doesn't cover fully decentralized services in that sense. Of course, care should be taken because it's still a bit gray as to what fully decentralized really means. But important to note that if a person just engages in crypto asset trading on behalf of himself, This is not done on a professional basis in that sense that you're not providing services, and therefore also you don't need an authorization. The second question is always which type of crypto assets, and as my colleagues already briefly touched upon, there are various types of crypto assets that are also covered under MiCAR, but this mostly goes towards which types of crypto assets are not covered by MiCAR. And I think the most important is to note that financial instruments in distributed ledger technology, so instruments that, although use the technology, act or are basically the same as financial instruments. Think about your shares or bonds. These are still covered by the existing MiFID regulation and directive, and therefore any types of services provided in relation to those assets require a different authorization, which is granted under the MiFID and the or existing national laws. So if we're talking about other types of crypto assets, think about utility tokens or more generic crypto assets that act as like a payment means in that sense. Those fall under MiCAR, and of course, therefore, those services as well are covered by MiCAR. The third question always is what type of services, crypto asset services, are provided, and this is relevant for many aspects. Of course, it speaks towards complexity of the business model and also complexity of the organization and systems, but also this is related to, for example, minimum capital requirements. So it's important to basically first qualify the services that will be provided, because if they are not crypto asset services in the meaning of MiCAR, then another authorization might be required. If they are, then of course each authority or national authority where you apply for authorization will ask which types specifically you intend to provide, and your authorization will cover only those. Coming back to the capital requirements, this is resolved similarly as under the MiFID. So those services that pose more risks require higher capital, and those that pose lesser risk basically require less capital, and the capital starts from 50,000 and goes up to 150,000 euros. The highest one for example, operation of a trading platform, and somewhere in the middle there you have custody and administration services. The next question always is, are there any applicable exceptions? Because again, if you don't need to apply, most likely you don't want to apply. And these exemptions mostly go towards if you're already authorized, for example, as a credit institution or investment firm, then you don't need to separately apply under MiCAR for a separate authorization, but you basically ask for extension, which is a bit lesser procedure in that sense. You notify your home state financial supervision authority, and you can start providing services quite quickly unless there is an issue. By head, I say it's something 40 working days or something. So it's a much easier procedure. Then, of course, it's always good to ask, is there any kind of like grandfathering regime or a simplified procedure that you could make use of? So MiCAR provides several options, but it's also dependent on the member states, whether they will use those exemptions or not. Those notifications must be done by member states by July 2024. So those exemptions and simplified procedures mostly go towards those service providers who already are providing crypto asset services and submit their applications. I think it was before 30th July 2024. But again, member states still have a discretion to decide whether they will use those simplified procedures, and exemption is very much dependent on what the national laws at the moment are. Are they equivalent or close to the MiCAR regulation? Then, of course, where to apply for authorization. And I know a lot of Estonians have been struggling with their existing licenses, because there are very heavy requirements as to what you need to have in Estonia where you have applied for authorization. And MiCAR is a bit milder in that sense in its language. It just says that basically you should have your part of your business in a relevant member state. So you must have something, and where you register, there you apply. So this is definitely a key takeaway for Estonians. And when to apply is, of course, related to the timeline, which was already covered. So the regulation applicable to crypto asset service providers is fully in effect by the end of 2024. So if you start countdown from there and take into consideration how long the authorization process will take, then most likely you should be starting preparations already now, because we just now we don't know whether the countries will apply any simplified procedures. So first I'll go a bit into the scope of CASP authorization, which is crypto asset service provider authorization. Again, for Estonians, what's on the slide is not very surprising, because the existing regulation is already quite close to this. But for those countries where the existing regulation is less strict, it's definitely important to see what's covered in the scope. And I think, of course, you need to show what your business model is, who are your clients, how do you plan to approach your markets, and so. But there are several more like organizational matters that are looked at. Coming from organizational structure, governance, internal control. This also goes towards the internal auditor requirements. Again, MiCAR here is a bit vague in its language, but we already know in Estonia, for example, that auditor and internal auditor will be required. And of course, all kinds of like outsourcing arrangements, business continuity. I think what might become or might be a bit maybe surprising, or at least takes a lot of effort, is the segregation of assets and custody arrangements. So this speaks for segregating the company's own assets from its clients' assets, how they are actually taken care of. A lot of IT requirements, and this connects to another regulation, which we call TORA, which is also already in place, but not in effect in that sense, that starts applying later. And of course, the key is always in a team, I think. So meaning qualified shareholders, managers, and other key function holders. So the fit and proper requirements that have applied so far in all financial sector will become applicable here as well. And of course, the bunch of internal rules. These go towards all those matters that are already listed here, plus other matters. The list is quite extensive. So how do you start? So first, we always start with the business model analysis and preparation of a project plan, which is always a kind of key. And then, of course, start preparing everything else. And of course, this 4 to 6 months mentioned here is based on our experience with other types of similar authorizations. but preparation will take time, and it's better to prepare right than to tackle those kind of gaps during the authorization proceedings. So, and usually we always recommend to have a kind of introductory meeting with the home state FSA, not to kind of surprise them with a huge package of documents when you submit. The application will be filed with the home member state financial supervision authority, who will be then conducting a preliminary review within 25 working days. If necessary, then they will give you a deadline for providing missing information. There's no clear guidelines as to what the deadline should be. So this is the discretion of the home state FSA. And then when hopefully the application is complete, you will be notified thereof, and then the home state FSA will start kind of further analysis of the package. This will take 40 working days. I say, although it's within, I'd say it's still minimum in that sense, because this period can be suspended for 20 working days in a first round, and then therefrom also during the process, but this will not extend your kind of total assessment period. So 60 working days, I think, is a fair to say that you should consider. And then, of course, when there's the application is complete, the assessment is made, hopefully the decision will be positive and you will be notified thereof within 5 working days, hopefully sooner. So this means that when you get your authorization, you can start providing services. In the documentation, you of course should address whether you do it immediately or you need some extra time to kind of test the systems, recruit staff, train staff, or whatever you need. So, but basically you're authorized to start providing services immediately. And then MiCAR also provides a short, like we call it a passporting procedure, but essentially under MiCAR, it's a formal notification procedure. So when you want to provide services also in other member states, you need to go through this procedure, file certain information with your home state FSA, and then this information will be forwarded to European Banking Authority within 10 working days, as well as to the relevant host state financial supervision authorities. And then latest, within 15 days after submitting the notification to your home state FSA, you can provide services across Europe. So now I hope I still have time to cover a bit about asset reference token issuer authorization. So this is to basically issue asset reference tokens if you're not a credit institution. So as Krista already mentioned, there are certain kind of exemptions. So for example, if you go only for qualified investors, then you're exempt in that sense. But if those exemptions do not work, you need an asset reference token issuer authorization. The scope resembles to the CASP authorization. So the topics are fairly similar, I'd say. Again, a lot of effort and a lot of scrutiny goes towards qualified shareholders, managers, and key function holders, but also to the crypto asset white paper and the legal opinion that Krista already mentioned. I wish I could go into a bit more detail here as well, but there are the relevant kind of technical standards that need to be shared under the MiCAR are still not yet published. So this scope here might go much more into detail, and there might be kind of new things that they add. So just this is basically like a basis for everything, and the details will come later. And about the authorization process, so this will be looked together with the kind of approval of the white paper. again, start with kickoff and preparations, similarly to CASP process. Again, here, 6 months is just based on what we think could be accurate, but it really depends on the circumstances, and I'd be careful here. Again, I would recommend to contact the home state FSA beforehand, not to surprise them with the authorization application. And once you're ready, you fill the application with your home state FSA, who again, similar to CAS process, will conduct a preliminary review first, which is 25 working days. And again, if necessary, set a deadline for providing missing information. Then a draft decision will be prepared within 60 working days. Again, here, you should consider that this deadline may be suspended for certain periods of time. So this is not like an ultimate 60 working days. And of course, during this period, they have a lot of consultation with various authorities like EBA, ESMA, and ECB. Also, in certain cases, with central banks of the relevant member states. This draft decision will be sent to them for review. This review is very specific in that sense that they will review only certain matters and provide their non-binding opinions to the home state FSA. And then the home state FSA, once they receive those non-binding opinions, of course, they will take a good consideration there. And within 25 working days, they should make a final decision on whether to grant the authorization or not. And of course, notify thereof within 5 working days. And once of course, we all hope that the authorization process will be success. Once it is successful, you get the authorization. This is valid throughout the entire European Union. So you can offer the asset reference tokens across Europe, and this also applies the same for the white paper that is approved. It's approved for the whole Europe then. So there's no this kind of separate like notification or passporting procedure. This is all from me. I hope you found it useful, and I will now give word back to Aquila.
Thanks, Heti, for so much information. Very useful. And next on is the topic of requirements related to conduct of business rules, safeguarding of clients' funds, conflict of interest, and complaints handling rules. And it will be covered by me, Akvilė Jurkaitytė, associate with Sorainen, Lithuania. So during this part, I will mainly cover several important things related to conduct of business of CASPs and issuers of crypto assets, explain the parallels with other existing EU directives and regulations in this regard. You might already heard that MiCAR text is somewhat similar to some of already existing EU regulations, including MiFID II, prospectus regulation, crowdfunding regulation, even electronic money directive or PSD2 in certain cases. So for instance, similar to the conduct of business rules under MiFID II, MiCAR provides that issuers and CASPs must act honestly, fairly, and professionally in the best interest of their clients and prospective clients. Additionally, issuers and CASPs are required to warn clients of the risks associated with transactions in crypto assets. Information and marketing activities have to be conducted in a clear, fair, and non-misleading manner. So I hope these are quite familiar concepts existing in the financial world. Now, a little more fresh approach is whereas it is required that the price policies, risks, and climate or environmental impacts of the crypto assets have to be communicated openly to the clients and potential clients. So ESG topic is also very much involved. It will be also particularly important to have sufficient governance arrangements and internal control mechanisms. As some may say that some of the major crashes of crypto asset service providers that were also discussed by Agneta earlier could have been avoided if proper governance was in place. So during my topic, some of the key requirements will be covered. To start with complaints handling procedure, CASPs. So this is a requirement applicable to both of them. CASPs and issuers shall have a complaints handling procedure and shall publish the description of these procedures. The key elements of the complaints handling procedure are that clients shall be able to file complaints free of charge with crypto asset service providers. Then that CASPs shall inform clients of the possibility of filing a complaint. Crypto asset service providers shall make available to clients a template for filing complaints and shall keep a record for all complaints received and any measures taken in response. Notably, for complaints handling procedure requirements are stringent for the issuers. For instance, issuers have accept complaints not only from clients, so holders or asset reference token of asset reference token, but also other interested parties, including consumer associations representing holders of asset reference token. Draft regulatory technical standards on this subject was already provided on 12th of July 2023. Some key concepts include that CASPs must ensure that clients are able to submit complaints by electronic means or by post. And for instance, in case of asset reference tokens, it should be also possible to provide the complaint in a paper form, and the complaints must be allowed to be submitted in all languages used by crypto asset service providers to market their services or communicate with clients, or where relevant, the language of the operating rules of the trading platform or crypto assets operated by the relevant CASPs, as well as in the at least one of the official languages of the home member state and each host member state. Similarly, as required in other regulations, the complaint must be acknowledged without a delay. The draft RTSs suggest that decision must be made in a timely manner, and in any case within 2 months. It will be also required to have the persons in charge of complaints handling and for them to have the necessary skills, knowledge, and expertise for the discharge of the responsibilities. And persons who are responsible for the complaints handling will have to report to the management body. So particular interest and importance towards this. Now further, it is required to implement and maintain effective policies and procedures in respect to identification, prevention, management, and disclosure of conflicts of interest. This is applicable with respect to preventing conflict between CAS or issuer and their shareholders or members, or any member, any person directly or indirectly linked to the crypto asset service providers or their shareholders or members by control, or with respect to conflicts between CASPs or issuers and members of their management body, their employees, their clients, or in case of 2 or more clients whose mutual interests conflict. So issuers and crypto asset service providers shall, in a prominent place on their website, disclose to their clients and prospective clients the general nature and sources of conflicts and interest, also the steps taken to mitigate them. Crypto asset service providers shall assess at least annually, review their policy on conflicts of interest, and take all appropriate measures to address any deficiencies in that respect. So the draft RTS was also already published on this topic by ESMA on 12th of July 2023. So it already provides some of the draft disclosures relating to the conflict of interest, also that the conflict of interest policy will have to be published by electronic means. So for example, on the website, that this policy will have to cover general nature and sources of conflict of interest. Everything that I was mentioning just a second ago. With respect to conflict of interest, proportionality principle will have to be, of course, followed. Now, where it concerns the issuers of asset reference token, it will be required to keep the reserve of assets. The idea of the reserve of assets is that it has to be composed and managed in such a way that the risks associated to the assets referenced by the asset reference token are covered, and the liquidity risks associated to the permanent rights of redemption of the holders are addressed. So this reserve of assets shall be legally and operationally segregated from the issuer's estate, as well as from the reserve of assets of other asset reference tokens. If, let's say, the issuer will offer 2 or more asset reference tokens, there should be segregated pools of reserves of assets for each asset reference token, and these pools should be managed separately. Issuers of asset reference tokens shall have a clear and detailed policy describing the stabilization mechanism of such tokens, and that would include list of assets that are referenced to that asset reference token. Also, the policy should describe how the asset reference token can be redeemed, provide associated risks and other information. Additionally, the reserve of assets must be independently audited every 6 months. It is also important to mention that issuers of asset reference token that invest a part of that reserve of assets shall only invest those assets in highly liquid financial instruments with minimal market risk, credit risks, and concentration risks. So I at least expect that there will be lots of explanations on some of the terminology here, how to understand what are highly liquid financial instruments, what is the minimal market risk and credit risk, etc. So EBA, European Banking Authority, of course, in close cooperation with the ESMA and the European Central Bank, will be the authority that will draft the regulatory technical standards that will further specify those liquidity requirements, taking into account the size, complexity, and nature of the reserve of assets and the asset reference token itself. As to deadline, these regulated technical standards have to be submitted to the European Commission by 30 of June 2024. Now, last but not least, also probably known concept that is within MiCAR is the safekeeping of clients' crypto assets and funds. And this requirement is applicable specifically to crypto asset service providers. Crypto asset service providers that hold crypto assets belonging to clients or the means of access to such crypto assets will have to make these so-called adequate arrangements to safeguard the ownership rights of clients, especially in the event of the crypto asset service provider's insolvency, and to prevent the use of clients' crypto asset for their own account. You've probably heard of those exchanges crashes and the huge insolvency cases because the status of crypto assets that were in custody of CASPs isn't clear, and it's not the case that those assets were properly separated, thus safeguarded in case of insolvency. So with this requirement, crypto asset service providers will have to safeguard their clients' crypto assets and funds. So essentially, CAS by the end of the business day, following the day on which clients' funds other than e-money tokens were received, will have to place those funds with a credit institution or a central bank. These requirements do not seem to be that much different from safeguarding requirements applicable to, say, electronic money institutions. Now, these complaints handling conflict of interest, safekeeping of clients' funds are rather generic requirements that will be applicable to a majority of the crypto asset service providers or issuers of asset reference tokens, say. And in addition to these general requirements, some particular crypto asset services have some specifically tailored requirements. You may see those on the screen. So let's say CAS providing custody and administration of crypto assets on behalf of clients will also need to have a custody and administration agreements with clients, register of positions, custody policy, concluding balances, separation of funds, wind down plan. Then, for instance, CAS providing the placing of crypto assets will need to have stringent conflict of interest requirements. So then, for instance, CAS providing reception and transmission of orders for crypto assets on behalf of clients will need to have procedures on prompt and proper transmission of client orders for execution on a trading platform and other. So there are also some particular requirements to some crypto asset service providers that provide the services of custody and administration, operation of a trading platform, exchange of crypto assets for funds or other crypto assets, execution of orders for crypto asset on behalf of clients, and placing of crypto assets. And these crypto asset service provider providing these services will also need a wind down plan, including the continuity or recovery of any critical activities performed by those service providers. So essentially, this plan shall demonstrate the ability of crypto asset service providers to carry out an orderly wind down without causing undue economic harm to their clients. And now moving forward to market integrity and abuse. MiCAR also introduces new rules that prohibit market abuse related to any type of crypto asset transaction or service, including unlawful disclosure or inside information, insider trading, and actions that are likely to lead to disruption or manipulation of crypto assets. These requirements are generally provided in Articles 86 to 92 of MiCAR. And some would say that these requirements are somewhat similar to with market abuse regulation. It's just a note that scope of requirements within MiCAR is not as wide as within the market abuse regulation. This September, during the presentation on MiCAR requirement by the Bank of Lithuania, it was expressed that those who are experienced with the MiFID II and prospectus regulation will have, say, less struggles on understanding MiCAR regulation, conduct of business rules, and similar, as these have many similarities to that what is existing in the financial regulation world already. However, more clarity on these conduct of business rules and the particularities is yet to be there once all the regulatory technical standards and information technical standards will be in place. So although we should already steadily prepare for the authorization, some of the policies and some of the standards and the rules are only to be observed until they will be published by ESMA or EBA. So that is it from my side. And I would like to now introduce Edvin Straba, Senior Associate with Sorainen Latvia, who will finish our webinar with the topic scope of MiCAR and interplay between MiCAR and other financial regulations. So we'll put all dots on I's here. And in the meantime, I would also like to mention that we are receiving the questions that will be covered during the Q&A session after Edvin's presentation.
Yes, hello, many thanks, Aquila, for the intro. Yes, so let's have a look at the scope of MiCAR and how MiCAR interacts with other regulation, which is important for CASPs, crypto asset service providers, and other entities operating in the crypto field. So Agneta has already enlisted the assets in her presentation being firmly within the remit of MiCAR. So now let's have a look at the assets that are out of MiCAR scope, or where MiCAR can, we can say, has limited applicability. So on the next two slides, I have divided the assets or services depending on whether they have any other regulation or not. So on this slide, I have enlisted the excluded or partially excluded assets, which, at least for the time being, don't have any other specific regulation, but maybe we'll have such in the future. So let's quickly go through those. First of all, it's DeFi or decentralized finance. These are crypto asset services provided in a decentralized manner without an intermediary. What comes to mind here is smart contract platforms and products and services built on those smart contract platforms. Then go central bank digital currencies. These are excluded due to entirely different risk profile compared to private tokens and cryptocurrencies. And currently there are no such in euro, but maybe we'll experience a digital euro at some point. But then it will be out of scope of MiCAR. Then crypto assets that are unique and non-fungible. An obvious example of it is NFT, or a non-fungible token. And finally, there's a limited applicability of MiCAR with respect to crypto assets that don't have any identifiable issuer. So cryptocurrencies such as Bitcoin, which fall under this category. And whilst MiCAR does not apply to these assets per se and doesn't regulate them, MiCAR still is applicable to crypto asset service providers that are providing certain crypto asset services related to such assets. For example, a crypto exchange exchanging Bitcoin. So therefore, we can speak of a limited applicability here. So apart from these items, it's important to note that assets that fall under some of the existing types of financial regulation, and Hetty in her presentation touched upon this topic as well in part. So financial instruments, e-money, deposits of funds, insurance products, pension products don't fall under MiCAR and continue to be regulated by that existing regulation. And I think that we should keep in mind that MiCAR emphasizes that the correct qualification of an asset should always be conducted on a case-by-case basis. So irrespective of how the particular issuer has called its asset or product, we should always look into the substance of the form here. And as regards financial instruments, which might be the most controversial issue, ESMA, which is the European Securities Markets Authority, is going to issue guidance on the qualification of crypto assets as financial instruments in the first quarter of next year. And we'll be looking forward to it. So now let's move to such important legislation in the field of finance as the AML legislation. And we also have received some questions here. Now, responding to one of the questions that we received on this topic is that MiCAR doesn't prescribe AML requirements as such. It's for the specialized AML legislation to govern the AML topic. So here we'll have a look at the so-called upcoming EU AML package and the changes it will bring to the crypto world. So first, let's have a brief look at the current situation. the term used by the wording of the existing EU AML directive currently in force is not crypto assets, as in MiCAR, it's virtual currency. So probably narrower concept. And the only two categories of obliged entities that have something to do with crypto assets recognized by the directive are crypto exchanges and custodian wallet providers. So obviously changes were required to make this regulation harmonized with MiCAR. So how does the future AML regulation looks like in the crypto field? First comes the new transfer of funds regulation that has already been adopted and will become applicable by the end of next year, simultaneously with the relevant provisions of MiCAR. The transfer of funds regulation does two things. First, it introduces so-called crypto travel rule, which we will discuss shortly, and it introduces amendments to the aforementioned fourth AML directive. But as regards the amendments to the AML directive, then the directive now will merely refer to MiCAR for definitions, although the directive and the regulation, which we'll speak later, will govern the substantive rules then regarding the AML requirements related to crypto assets, but the definitions are contained in MiCAR. So therefore, all licensed CASPs, crypto asset service providers, will be AML obliged entities, irrespective of the particular type of activity CASP is engaged in. And I should also say that I won't go into details what exact AML rules are applicable to crypto asset service providers. I think we can have separate webinars on this, but here we'll just consider that CASPs will be AML obliged entities. So what pertains to the crypto travel rule itself, which is also introduced by the transfer of funds regulation, is that it is similar to the existing rules for the transfer of funds. So in a nutshell, the travel rule means that the crypto asset service provider of the originator of the crypto asset transfer, similar as the bank of a player in a wire transaction, must provide to the crypto asset service provider of the beneficiary or recipient of those crypto assets certain information alongside the transfer of those crypto assets. And this information is in a simplified manner listed here. So it's name, address, distributed ledger address, and other information on the originator of the payment, and also a similar set of data on the beneficiary. So these are the obligations of the originator's crypto asset service provider. And in turn, the crypto asset service provider of the beneficiary or of the recipient of those crypto assets must be able to detect if the incoming transfer contains or is accompanied with the required information, or whether something is missing, or whether some information does not match what information that crypto asset service provider has on the beneficiary. And before making the crypto assets received via this transfer, before making them available to the beneficiary, the crypto asset service provider or the beneficiary must verify the accuracy of the information received alongside the transfer on the basis of documents or information obtained from a reliable and independent source. So the next two are draft legal enactments from the AML package. That should be pretty close to adoption. However, please note that it's still work in progress. There's still an ongoing trialogue procedure among the EU institutions. So these are the new AML directive and the AML regulation. So yes, for the first time, alongside the directive, which is an legal enactment of European Union, which is not directly applicable, which must be transposed into national laws of the EU member states, there will be an EU regulation, which will be a directly applicable European Union legal enactment, and which will govern various matters related to customer onboarding, to customer due diligence, and other substantive matters required to AML compliance. And the main novelties related to crypto assets are enlisted here. So transactions in crypto assets exceeding €1,000 will mandate the duty to conduct customer due diligence for the crypto asset service provider. Enhanced due diligence measures will be required for crypto asset transactions involving a self-hosted address. And there are also several prohibited activities, such as correspondent relationships with unregistered or unlicensed crypto asset service providers, then anonymous crypto asset wallets, as well as any other measures allowing the anonymization of the customer account holder. So imagine any crypto tumblers, and merchants will only be able to accept payments in crypto for the products or services up to €1,000 from self-hosted or from an anonymous, I should rather say, crypto wallet. So this is as far as the AML regulation is concerned, and the last piece of legislation that we're going to very shortly discuss in this section is the EU Digital Operational Resilience Act, known as DORA, which was also mentioned in Hetty's presentation. It entered into force this year in January and will apply from January 2025. So DORA aims to consolidate and upgrade the information and communication technology risk requirements for all financial entities, including CASPs. So previously, these requirements have been spread over different acts of financial services legislation, such as the Capital Requirements Directive, PSD2, or MiFID, and others. So as CASPs will be considered financial entities, then DORA will be applicable to CASPs as well. And its main pillars are ICT risk management, where it prescribes principles and requirements, ICT third-party risk management, which includes measures aimed at monitoring the risk of those ICT service providers, and also key contractual provisions in the outsourcing agreements with those ICT service providers. Testing of digital operational resilience, reporting of major incidents to the competent authorities, and for the first time EU-level oversight arrangement for critical ICT third-party service providers. So, for example, cloud service providers. So this is to flag that this act will form an important part of compliance, of the compliance package of an entity wishing to be licensed for MiCAR. So this is my last slide. Many thanks for your attention, and the floor is back to Aquila.
Thank you, Edwins. So thanks to each and every speaker today. We have received some of the questions before the webinar, and we would like to cover those. And in case there will be any other questions that are related to the topic, please ask them as well. So we have received the question regarding placing of crypto assets. What is it exactly? It seems mostly related to the marketing on behalf of or for the account of the offerer, or a party related to the offerer of crypto assets to purchaser. But is it for ICOs? Is it for staking or something else? So I will give the floor to Heti to cover this one.
Yes, hello. So I think, as already mentioned, MiCAR draws a lot of its kind of content from the existing MiFID, and therefore also the placing as such, I think, should be interpreted in the line of how it's interpreted in MiFID, because it's considered equivalent in that sense. And so far, we don't have any better guidelines. So what it essentially means is providing a service to the issuer of finding investors, especially in the context of primary market activity. So just to find basically investors who would invest into the issued tokens. In MiFID, it's also there's a kind of an alternative where this is done on firm commitment basis, meaning when, for example, somebody wants to issue 1 million tokens, and then starts providing service of placing, so finding investors for those tokens. It's also an option to kind of do it on a firm commitment basis, meaning if there's all those tokens do not find an investor, then the service provider will actually, based on this firm commitment, acquire those tokens that are not allocated to specific investors. But yes, this is mostly connected with finding investors.
Thank you very much. Next question we received is, if time permits, please clarify the topic of significant e-money token AMT regulation. Will it, in your opinion, require additional different licensing for current virtual asset service providers, for example, for listing trading on the exchange? Or does the stricter licensing EBA as supervisor apply only to the issuer of electronic money token? E-money token. Kirista, the floor is yours.
Yes, thank you. So yes, we covered the concept of significant e-money tokens and asset reference tokens during the presentation part. So yes, to confirm, the supervision from the European Banking Authority and all the additional requirements would only apply to the issuer. But as it was also mentioned, the issuer can provide written consent for any other person to offer or admit those e-money tokens to trading, which would then also apply to significant e-money tokens, meaning that any CASP could potentially be that certain person. There are some requirements to make this kind of person qualify to be able to do that. But the additional requirements mainly apply to the communication and sort of the additional things with regards to offering and admission to trading, but the overarching authorization requirements only apply to the issuer. So the type of activity license, the CASP involved, would not change from this arrangement. However, it might be necessary to have a look at how MiCAR and the e-money directive sort of interplay if that situation does come up. That's it for this question.
Thank you very much. Next one is coming back to crypto asset service providers. The question is, do crypto traders have to have the trading license? What risks are for users if they trade at a platform that doesn't have license? What risks are for employees of the platform?
I think this is for
Hetty,
me, yeah?
you.
Yeah,
Yes.
right. So as already briefly touched upon, crypto asset service provider authorization is required if a person provides relevant services on a professional basis. So this means if you're trading on behalf of yourself and not providing this as a service to other people, persons, then you don't need an authorization. I think this is the key takeaway here. Now, the risks related to trading on a platform that doesn't have a crypto asset service provider authorization in place. Well, since the authorization also means that the relevant authorities have verified that the service provider actually complies with the MiCAR requirements. So this means also on a capital requirements, also, for example, segregation of clients' asset, the transfer rule, and all those things. Then these rules are made for protecting the service users. So if you trade on a platform that doesn't have an authorization in place, then you kind of just don't get those benefits from MiCAR. But other than that, if you're doing this on behalf of yourself, it's not an issue. If you're doing the trading on behalf of clients, so basically transmitting their orders or executing their orders on a platform that is not authorized, this is most likely a bigger issue because you take a responsibility with your clients as well. So, and I think there was a question about employees of the platforms. This is mostly question about the national laws and how employees are protected. Also the managers and their reliability under the national laws. Of course, there's some elements also in MiCAR, but most likely it's a question about the national law and how it protects the employees. The whistleblowing is also a topic here, and this to extent protects also employees who are doing those notifications in good faith. So this also should be taken into account.
Thank you, Hetty. One other question, will this affect the transparency of P2P crypto traders? Will the regulation make it easier to identify the traders of P2P crypto? Will the regulation restrict or complicate trading between EU and non-EU countries? So I will give the floor to Agneta.
Thank you. This is a very multifaceted question, I would say. The short response is that MiCAR does not really cover peer-to-peer transactions. So basically, this regulation is focused on professional service providers of crypto asset services, as Hetty just mentioned. So actually making transactions between two separate persons who do not do this on a professional basis, but do this on their own account, it just doesn't fall under the scope of MiCAR. So I would say that this regulation does not really affect this at all. And as a consequence, it also does not help in transparency of these types of transactions. However, it is to an extent addressed under other European Union rules. One of this was mentioned by my colleague Edwins when discussing AML requirements relating to crypto. And there was a final part of the question, will this regulation make transactions between EU and the rest of the world more complicated or easier? Well, I guess we'll just have to live and see, because on one hand, regulation does actually help because it creates some structure and some foreseeability, but of course it will make some restrictions as well. Thank you.
Thank you very much, Agneta. That's it from the pre-webinar questions. And I see in the Q&A section, there are a few new questions that were not yet answered in the written form, and these are relating to the DeFi, so decentralized finance, essentially. One of which is referring to, are there any criteria to determine whether the services are provided in a fully decentralized manner? One of the speakers mentioned smart contracts as a material condition for such a manner. However, how to be with the DEXs built in private blockchains? Are they decentralized enough to be fully decentralized? This exception creates a lot of questions to my mind. And the other one, as full decentralization is still vague under MiCAR, how do you think can crypto staking be seen as partially decentralized under MiCAR? Can centralization of the liquidity in case of the DeFi lending be seen as partial decentralization? So I will try to briefly cover this. Essentially, there's this thing of fully decentralized activities that are not covered by MiCAR, and to our knowledge, usually it is explained that what is fully decentralized will be assessed on a case-by-case basis. So far, at least we are not familiar of the criteria that could help us to figure what is decentralized and what is not. The European Systematic Risk Board has published this report on crypto assets and decentralized finance in May 2023. To our knowledge, even the supervisory authorities are relying on the report in respect to decentralized finance and DeFi. So if anyone will like to receive this report, the link to it, please approach us, and this may give you a little more clarity on DeFi. However, to this date, it is very speculative to assess what will be considered as decentralized fully or not. So I think that would be it. And if there will be any other questions, please approach any of the speakers from today's webinar. You will get the recording of this webinar, including the slides after. As mentioned in the very beginning, we are also considering of creating a series of events related to MiCAR, crypto, AML, and similar. So stay tuned and follow us. And in case you have any topics in your mind that would be interesting to have in a webinar format, please also approach us and share your ideas, and we will gladly consider for the future reference. I thank to everyone who participated today, to all of our speakers and all the participants. Let's stay in touch and have a wonderful day.